welcome to The Firm. On the show this week, why the imposition of tax on a tax-free zone is not a breach of promise. And can't a company change its mind? The curious case of Fresenius Kabi. In 2006, then Commerce Minister Kamal Nath said, the SEZ policy is meant mainly to provide a one-stop shop, doing away with the multiplicity of controls and clearances, along with fiscal concessions and simplified procedures. That means one of three things that made these economic zones special was fiscal incentives. Yet, the Karnataka High Court says the recent imposition of minimum alternate tax or MAT on SEZs is neither a breach of promise nor a violation of the doctrine of legitimate expectation. By upholding the constitutional validity of taxes levied on SEZs, the Karnataka High Court has become the first High Court to rule on this rather contentious issue that has seen a spate of appeals in the last 2 years. Payaswini Upadhyay reports on the ruling and its impact.
It's a violation of the doctrine of promissory estoppels and doctrine of legitimate expectations. That's the argument software company Mindtree and several others made when they challenged the levy of 18.5% minimum alternate tax and dividend distribution tax on special economic zones. These taxes were imposed by Budget 2011, 5 years after the SEZ Act promised companies in special economic zones tax relief on profits and dividends. Though the SEZ Act and the pursuant amendments to the Income Tax Act did not specify a time limit to these tax incentives, it was well understood that the SEZ policy was predicated on tax relief, and that's what made these economic zones special. Hence, when faced with a sudden change in policy in 2011, the companies argued that they had made investments expecting these incentives to continue and that the withdrawal of these exemptions is abrupt, arbitrary and unfair.
The way doctrine of promissory estoppel works is that if a promise is made by a government agency usually, and a person on the belief that this promise will be implemented, he has altered his position. Then in that particular case, if the government agency goes back on its promise, the person whose position has been altered can go to the court on the basis of doctrine of promissory estoppel and say that the intended benefit should be made available to him as promised.
Historically, courts have upheld that a legislation will override the principle of promissory estoppels, but the same has not always been applied to executive action. In 1978, in the Motilal Padampat Sugar Mills case, the Supreme Court upheld the estoppels principle against the UP government that withdrew the promised sales tax exemption to new industrial units.
If you ask me from a legal standpoint, at least as the law stands by and large, is that you cannot invoke theory of promissory estoppel against the legislative action. Okay? So, legislature can do anything in general, except if it is violative of some constitutional provisions otherwise. But these actions can lie against the executive action.
In the growing business environment, in the environment where the industries are growing and where the government leads the industry and the business houses to go in certain directions. In these areas, in these matters of tax legislation, one has to have a fresh look. That if on the basis of the assurances given by the Parliament, if on the basis of the promises given by the Parliament, if the taxpayers have made certain sacrifices, if they have made huge investments acting on that assurance, then they should not be hit by any law which is thereafter passed by the Parliament. So it is here that a fresh look is necessary.
A fresh look that Mindtree, Opto, Biocon and several others did not get the benefit of. A single judge bench of the Karnataka High Court ruled that the estoppels principle cannot be used against legislative action. It held MAT and DDT as constitutional on three grounds. First, that every tax exemption and incentive should have a sunset clause, and by withdrawing the exemption to SEZs, the government is correcting the lapse on its part. Second, the withdrawal of the exemption removes the inequality between SEZ and other companies. And third, the exemptions provided to SEZ companies resulted in erosion of tax base.
First of all, it's not at all well settled that every relief has to have a sunset clause. There is no such legal compulsion. There is no such parliamentary term. There are several provisions in the Act. Say, take for example, investment allowance, which was there earlier. There never was a sunset clause. It was intended for the development of the entire industry. And it was regarded at that time as a part and fundamental feature of the Income Tax Act. So it is wrong to say it is well settled that every exemption should have a sunset clause. That is number one. Number two, question of discrimination. Here is not a case where those who have not set up the SEZs are complaining against the persons who have set up the SEZ. Frankly speaking, discrimination point is totally irrelevant. It is nobody's case that there is a discrimination. And thirdly, the point which is that erosion of the tax base. Well, with respect, I say the government when it had introduced, the parliament when it had introduced this measure, it had done it with its eyes open.
Theory of legitimate expectation is that where there are certain fundamental legitimate expectation among the members of the society or even vis-a-vis the government, then that can possibly be challenged under Article 14, because it is something like principles of natural justice. Okay. For example, right to be heard before any case is this audi alteram partem, right? That is fundamental principle of natural law. Similarly, legitimate expectation is also being construed as the fundamental principle of natural law. In fact, some of the decisions internationally have gone to the extent of saying that even when you change a statute, okay, at least you should have consultative process if it is suddenly what you call adverse to the promise you made by way of statute. Okay, so unfortunately the judgment does not go much in detail or does not discuss this theory of legitimate expectation, especially vis-a-vis Article 14.
The amendments introduced in the Finance Act 2011 have adversely affected 584 SEZ developers and thousands of units operating in these areas. And so, in the last 2 years, several companies have contested the constitutional validity of MAT and DDT on SEZs in Bombay, Madras, Andhra Pradesh and Gujarat High Court. For instance, 2 Adani Group companies had moved the Gujarat High Court in May 2011. Besides the argument of violation of estoppels and reasonable expectation principle, Adani argued in its petition that the Finance Act cannot amend the SEZ Act and that any imposition of tax would have to be done by amending the SEZ Act itself.
Well, I think that's a weak argument. You see, essentially, it's the law of the parliament, ultimately. The SEZ Act was the one which brought in the relevant provisions in relation to SEZ units in the Income Tax Act. And now what the Finance Act is doing is that the Finance Act is altering those provisions in the Income Tax Act also and in the SEZ Act also. So from my perspective, it's a legislation which is passed by the Parliament, and that argument I don't think will hold water.
The decision by the Karnataka High Court is by a single judge bench, and so experts say it would have only a persuasive effect on other pending cases in various high courts.
This judgment of the Karnataka High Court is delivered by a single judge. It is not a judgment of a division bench, which is always constituted by 2 judges of a court. So, always in the hierarchical system, if suppose this matter goes before the Bombay High Court or before the Gujarat High Court, where it will definitely be heard by a division bench straight away. None of these 2 benches are going to take this decision as a binding decision, because it is from a single judge. And plus, apart from that, as for the reasons which I've earlier explained, in certain areas there is a flaw in the reasoning, and therefore for me it is absolutely a fresh battle.
379 notified SEZs, 110 operational with exports of over 2 lakh crores and thousands of companies operating in these zones. All of them would be closely watching the decision from other high courts. In Mumbai, Payaswini Upadhyay.
More on that story when other high courts come in with their verdicts. We'll be following that space closely. All right, let's take a quick break. Coming up on the firm, can't a company change its mind? The curious case of Fresenius Kabi.